Module 2, The Economics of Utilizing Paralegals. Developed under the leadership of a team that includes paralegals from both DuPont and primary law firms, DuPont has developed a paralegal utilization model that provides guidelines, tools, and metrics for primary law firms to use in evaluating and improving their efforts. A part of that paralegal utilization model states, faced with increasing competition, law firms are looking at ways to maximize profits. At the same time, corporate America is looking for better service at a lower cost. Law firms are turning to paralegals to help them meet these demands. One of the reasons that the increased and more effective utilization of paralegals makes sense to the law firm today is the economic advantage provided by the use of paralegals. Economic advantages to the firm are provided through the following: fixed revenue amounts, blended rates, and other alternative fee arrangements dictate that work be completed at the least possible cost. In many cases, paralegals fill this niche. Delegating responsibility for legal work to paralegals provides the attorney with more time to handle complex legal issues, generating more overall revenue. Experienced paralegals command higher billing rates, which have a significant impact on a firm's bottom line. Courts are adjusting fees awarded based on the value of the task performed. Fully utilizing paralegals increases job satisfaction and retention. In addition, introducing paralegals to clients and making them a part of the firm's marketing inspires responsibility and loyalty. The Legal Assistant Management Association, also known as LAMA, has shown the profitability of using paralegals in one of its surveys. That survey showed that by utilizing the services of an entry-level paralegal, an employer realizes a contribution to profit of $41,500. The utilization of services of an experienced paralegal increases profitability to $62,800. The increased utilization of paralegals is also reflected in the recoverability of paralegal fees, as courts have recognized the lawyer-paralegal approach. Today, in many cases, the fees charged for paralegal services are not only recoverable, statute and case law encourage them. It was in 1984 that courts first recognized that a paralegal or law clerk should more appropriately perform certain types of work previously done by a lawyer. In 1989, the U.S. Supreme Court affirmed the ruling in Missouri v. Jenkins by stating that the district court correctly compensated the work of paralegals, law clerks, and recent law graduates at the market rate for their services rather than at their cost to the attorney. This clearly set the precedent that allows firms to bill paralegals as part of the professional staff rather than as overhead, as had been done in the past. Lipset v. Blanco, a 1992 decision by the Second Circuit Court, stated that the efficient use of paralegals is, by now, an accepted cost-saving device. Recognizing this reality, courts generally allow hours reasonably and productively expended by paralegals in civil rights litigation to be compensated at market rates when constructing fee awards. In a February 2001 request for reimbursement of attorney's fees to a court in New Jersey, a lawyer requested fees of $90 per hour for the paralegal. The paralegal had over 20 years of experience and was a PACE-registered paralegal. After a hearing in 2002 and a review of the paralegal's credentials, the court granted the award of paralegal fees at $90 per hour. The use of experienced paralegals is of great value to a client. Including paralegals in the handling of a matter is a cost-effective method that many clients are now looking for. A paralegal can offer increased communication with clients and, as a result, generates more client confidence in how their matter is being handled. This also increases the efficiency in which the very details of the matter are handled.